Hey, Andy, can you hear me?
Hey, Ken, how are we doing?
Good, good.
Gonna give it another minute, then we'll jump on.
Sounds good.
Good afternoon to everybody that's just joining. I'm Andrew Rapaki. I'm gonna give it another minute before we kick off the webinar. All right, good afternoon, everybody. I'm Andrew Rapaki, and today I'm gonna present to you everything you need to know about protecting your SaaS with patents and intellectual property. Okay, today's webinar is really designed to kind of be a down and dirty on what you as a software founder or you as a software company need to know on how best do I protect my intellectual property, right? How do we create a defensive barrier around it? How do we gain a competitive advantage? What can intellectual property do for you, right? So with that being said, I'm going to kick it off here. What I'd like to first start off by doing is I'm going to go through my slideshow fairly quickly and leave quite a bit of time for questions and answers. Okay, and that's designed to really help answer your questions. If I don't get to your question, or if there's a question that comes up after the webinar, our link is below. Please shoot me an email. Happy to answer it. If I could get on a call with you, even better. Okay, but for today's purposes, there's a questions and answers button in the webinar. If you have a question, please put it in the questions and answers block, and I will answer it at the end in the order they're received. Okay, so with that being said, let's get started. I want to first thank you for joining us. I know it's Good Friday. It's a Friday afternoon, so I do appreciate it. I promise I'm going to give you the best information I can in as succinct of a way as I can, because I know that the best webinars are usually the quickest and most straight to the point. Okay, so I'm Andrew Rapaki again with the Rapaki Law Group, and I'm going to go over protecting your software today. Okay, so today's topics, we're going to basically go over, how does intellectual property apply to your SaaS company or your software company? Okay, first question, and the question that we always get is software patentable, right? I've heard rumors it's not, my friend told me it's not. We're going to address that right off the bat. Okay. Then what we want to talk about is, hey, let's talk about your particular software and some of the things that you should be thinking about in terms of, do I have something patentable? What should I be looking for in terms of patentability, right? What I have nowhere to, I don't know where to start. Is it a feature? Is it a functionality? We're going to go through that. Okay. We're going to talk a little bit about, where do we go from here? Do we start with a prior art search? Is a provisional a better fit? We're going to discuss that as well. We're going to talk to you a little bit about drafting, right? I think drafting is important to understand for founders, for inventors, in the sense that, there's some do's and there's a lot of don'ts. So we're going to address each one of those today, okay? And kind of give you some good practices from what we've seen from the years of doing this. To talk to you a little bit about filing techniques, right? Is it better to file a standard application, or should we try and use a track one prioritized examination technique? We're going to talk a little bit about design patents, copyrights, trademarks, okay? And we're going to really talk about that at the end of the presentation. I'm going to address it here in the beginning shortly, but we're really going to get in depth on that at the end. And then we're going to have questions and answers. And then my game plan is to try and give us as much time as we can to answer those questions for you, okay? That being said, I'm Andrew Rapacki, okay? I'm a registered patent attorney. I'm the managing partner at the Rapacki Law Group. We're a boutique firm. We've got 8 patent attorneys and patent agents. We draft patents in a variety of industries. We really, I would say 90% of our industries are software related, whether that's SaaS patents, that's AI, machine learning, it's blockchain, it's fintech, software as a medical device. Okay, I was very lucky, and I got to attend the United States Naval Academy and serve my country as a naval officer for about 8 years before I became a patent attorney. Okay, and then I went to law school at Florida State, and then I entered private practice at that point. Okay. As it's shown here, we really focus on software, artificial intelligence, blockchain, software as a medical device, mobile app patents, automotive hardware and software components and technology, aerospace and defense, based on my background in the military, and then design patents. Okay. I have litigated trademark, copyright, and patent cases at both the United States Patent and Trademark Office and in federal courts around the country. Okay, so we have some experience in both the prosecution, the drafting of your application, as well as defending and bringing claims of infringement. Outside of practice, I'm married. I've got a 9-year-old and a 3-year-old. As you can imagine, they keep me pretty busy. When I'm not doing that, I like to be on the golf course or just spending time with friends and family. Okay, so let's get going. All right, so today we're going to talk a little bit about, how do we protect patents, or how do we protect software? I'm sorry. First and foremost, we're going to talk about patents, right? Utility patents are really going to be the bulk of what's applicable to you guys. Okay, we're going to talk a little bit about design patents in protecting icons, mostly graphical user interfaces, screenshots. We're going to talk about trademarking, to build brand recognition for your company. And then we're going to talk a little bit about, how do we protect your software code? How do we protect that object code, that source code? What are the pros and cons of the different forms of intellectual property? As I mentioned earlier, I'm going to talk about that towards the end of my presentation. So I'm going to just kind of plow through that right now. Okay, first question, and the $1 million question that we get all the time. Is software patentable? Okay, I included this chart in here because I think it's very valuable in understanding whether or not software is patentable. The overwhelming answer is absolutely software is patentable. Okay, to give you some data, in the latest data from the USPTO from 2021 is about 63.9% of all patents issued in the United States were software related. Okay, you'll notice if you look at the graph, and I apologize if it appears a little blurry, from about 2015 to present, over 55% of all patents issued are software related. So you can see the trend is leaning towards automation. The trend is leaning towards software. The trend is leaning towards AI. Things like ChatGPT are in the news every day. People are looking for automation to make jobs more efficient, to make their processes more lean and efficient. So to give you an idea, 63% of all patents issued in the last 2 to 3 years were all software related. Another interesting fact I put on here was the European Patent Office is at about 50%. I think that the number right now is 49.5%. So you're seeing a big trend in Europe towards patenting more and more software. Okay. So to answer that $1 million question of, is your software patentable subject matter? Absolutely. Okay. Is your particular software patentable? Well, we'll find out by going through some techniques and what you should be thinking about as we look to protect it. Okay, so let's talk a little bit about the patenting process for software. Patents are designed to do 2 things. Patents are designed to protect in the software setting, your functionality, right? What does your software do, right? When I put an input into the system, what is the unique functionality that creates some sort of unique output? Okay, there's 2 types of utility patents that protect functionality. And again, utility is a fancy way of saying what we're protecting here is functionality, right? Whereas you'll hear us talk a little bit later on about design patents, okay? And design patents are more ornamental, right? Non-functional, protecting the way something looks. For this exercise right here, we're going to be talking about utility patents and protecting the functionality of what your software does, right? So the statutory requirements, the federal requirements to get a utility patent is that it has to be new and novel, okay? It has to be useful, okay? It has to be non-obvious, okay? And most importantly with software, it cannot be abstract, okay? So when we talk a little bit about things that are not patentable, we talk about abstract ideas, right? And what does that mean? I'm going to talk about the software, that in a software context in a minute, but what we can clearly define as abstract are natural phenomena, laws of gravity, mathematical formulas, products found in nature, okay? Those are not considered patentable subject matter, okay? So if you're trying to patent something, you know, a lot of times I'll see, you know, people will combine fruits or nuts or something in nature. Okay, and when you're just taking raw materials in nature and not doing something extra with it and putting them together, the chances that you're going to receive an abstract or a 103 obvious rejection are going to be very high. Okay, let's talk about abstract in the sense of software. Okay, 2014 was a milestone in the software patent world, right? What happened in 2014 was Alice versus CLS, a key Supreme Court case that found in that particular case that software, that case held that the software was too abstract to be patentable. It didn't do enough to meet the threshold to be an inventive concept. Okay, and it was found to be unpatentable under 35 USC 101. Okay, what happened after Alice was kind of a period where there was not clear examination proceedings from the USPTO. There was not consistent examination procedures, and there was a lot of uncertainty on what was considered patentable and what was considered not patentable. Okay. You know, 2016, 2017, there was some case law that came out that kind of shed some light on what is considered patentable. Okay, I think the biggest milestone we really hit was the updated examination procedures from the USPTO in 2019. Okay, those examination procedures really outlined a 2-step Alice process, okay, on what was considered patentable subject matter, right? It looked at, you know, what is an inventive concept, what is enough to be considered patentable subject matter and not merely abstract, okay? So again, you know, what kind of happened after Alice in 2014 was this period of uncertainty. I think that really sparked the question, is software patentable? Is it ever going to be patentable? And a lot of this rumor mill that software was just not protectable, I would argue probably originated following that Alice case in 2014. Okay, so let's talk a little bit about, let's keep going here, and let's address some of these points, right? Novelty, right? The most important part of any application is clearly identifying the point of novelty, right? That novelty needs to be fleshed out. That novelty needs to be clearly outlined in your claim set. Okay, if you ever read some of our articles, we really hit on emphasizing what is the point of novelty. Is that point of novelty clearly defined? Because that is exactly what the examiner is going to look for. Okay. We'll talk a little bit about some of the things that are going to support your claim set, like your detailed description, your specification, even drawing figures, right? But remember, the claims of your patent and clearly identifying that point of novelty is going to make or break your patent. That is the most important piece of your application. That's really the heart of your patent, okay? We talked a little bit about non-obvious, right? The idea of non-obvious is that your patent cannot be a variation, or it cannot be an obvious change to something known in the arts, right? Again, the examiner often will issue a 35 USC 103 obviousness rejection by combining two or more references and saying, okay, when I combine these two references together, in combination, they disclose each and every element of your disclaimed or of your claimed invention, right? Again, if we're able to look at the primary reference, if we're able to knock out one of those references, that 103 argument will be traversed and that argument will fall. Okay, I think this is probably the most important slide for any software inventor, any software founder, any software company. What should you be thinking about in terms of protecting your software? Okay, I think the first thing that we need to address before we even look at, where do I move forward is to ensure that we're meeting the statutory time requirements. Okay, in patent law, there is a statutory time bar under 102A. Okay, what that means for patent founders is that you have 1 year from the date of public disclosure, okay, to file a patent application on your technology, whether it's your software, your AI, or it's no longer patentable. Okay, arguably, if you're making substantial updates, that can reset the clock, but really, the date I want you to remember is you have 1 year from the date of public disclosure anywhere. Okay, what does that mean? That means if you are speaking about your software outside the United States, that is still public disclosure. That disclosure can be used against you. If you're selling the product outside the United States, that is public disclosure. Okay, what I want you to keep in mind is public disclosure is not just limited to what happens here in the United States, but it's anywhere in the world. Okay, so remember, if you're creating software, you have 1 year from the date of public disclosure to file an application. Now, that can be a provisional patent application, that can be a non-provisional patent application, that could be a design patent application, but that has to be 1 year from the date of public disclosure. I want to emphasize that. That's an issue that we run into more times than not, and something that needs to be addressed. Okay, let's talk about what you should be thinking about. Excuse me here for just a moment. When you're looking at your software, some of the things that you should be thinking about is from a high level, what's your inventive concept? Okay, what is your software doing? What is novel about your software? Meaning, hey, what is it that your system offers that others don't? Okay, once you've kind of fleshed out what that is, now we want to be thinking about, okay, is it a specific feature that is novel, right? When we think about a specific feature, we think about Amazon's one-click, right? That's a feature that bypasses the cart shopping and allows you to purchase it without without having to put it in the cart and check out the traditional way. I think if any of you guys have kids, that's the biggest danger when they learn how to hit the one-click button. Okay, The second thing you should be thinking about, is it a specific functionality, right? I would say the majority of software is a specific feature and functionality that creates some sort of output, okay? The last thing you want to be thinking about is it a combination of those? Most of the time it is, okay? One thing to be keeping in mind is, people talk about, well, what if I've made an improvement over existing technology? Does that, and it's not out there. The key is your software, is that improvement, is that update providing a technical improvement over existing technology? Okay, if the answer is yes to that, it's very, very important to really lay out where is the technical deficiencies in the existing technology, right? The existing technology doesn't allow the processor to do A, B, or C, right? My technical improvement addresses these and does the following, okay? So yes, if your system offers a technical improvement over existing technology, arguably that's patentable subject matter, and I want to talk to you, okay? Last point on here is if you have questions about existing technology, if you have questions about your software, if you think, hey, there might be something in here that's patentable subject matter, give us a call, right? Any one of our attorneys are going to walk you through what you should be thinking about. They'll do a quick screen share on Zoom or Teams, and look at your software and kind of give you their thoughts, okay? But these are the things that I want you as a founder to be thinking about, because these are really the foundations from where we start. Now, let's take a minute to kind of take a step back. Once you've identified these, now what's key is really fleshing out that novelty. Can we succinctly describe what the software and that point of novelty are? Okay, when you're able to do both of those things, you're really in a great position to move forward with an application. Okay, and where you go from here, we're going to address on the next slide. Okay, the starting point. Okay, there's a lot of ways that you can start the patent process. Okay, a lot of times if you're very early stage in the patent process, one of the things that you might want to be thinking about doing is going right into a provisional patent application. Okay. I always kind of use with our clients, the beta as the bright line test. If you're pre-beta, I think you should really be considering provisional patent applications quite a bit, right? The reason for that is a provisional patent application is going to allow you to file, okay, establish your filing date with the USPTO, meaning now you're considered patent pending. It's going to allow you to take those 12 months and really flesh out what that technology is, right? Make some minor changes, make some minor tweaks, get that system to the point, 6 months down the road, 9 months down the road, where you can pick up the phone and you can say, Andy, I'm ready to convert my provisional to a non-provisional patent application. Okay. The advantage to that process is, if we can file that non-provisional within that 1 year, okay, we can maintain that priority date. Okay, and what does that mean? It means that the USPTO will treat the date you filed your non-provisional patent application as the date your provisional was filed. Okay, so in a first to file system, that's very, very important. Okay, so we want to, so I don't want you to necessarily think, oh, my invention's not fleshed out enough. There's no way to protect it at this point. Provisionals are a great form of protection when you're early stage. Okay, let's talk about the other type of application, which is non-provisionals. Okay, remember, if you ultimately want a patent application, if you ultimately want a issued patent, you have to file a non-provisional patent application. Okay, that application will go to an examiner. That application will be substantively examined. Okay, the examiner is going to do a prior art search to see if there's other prior art references that disclose your invention, right? They're going to look at it and say, is this patentable subject matter? Have they met the threshold for the inventive concept? Okay. So remember, if you want, provisional patent applications will never turn into an issued patent. Non-provisionals will. okay? I would recommend, if you're going to do a prior art search, the point of the most accurate, okay, and fleshed out prior art searches is right before your non-provisional patent application. One of the dangers of doing a prior art search early on, pre-provisional, is that you don't have enough detail in there because you're early stage to get hyper accurate feedback, right? And really understand what other technology is out there, how broad is that technology field, okay? How do I draft the best claims based on prior art to get my application through, okay? If you are ready to go with a non-provisional patent application, a prior art search is a great starting point, okay? A good prior, and I always say this to my clients over the phone, and I apologize if I'm echoing the same things. A good prior art search is going to tell the client if what they have is patentable or not patentable. A great prior art search is going to give them an idea of the landscape out there, okay? Meaning how much similar stuff, how much similar technology is out there. If I can understand that landscape, now I can figure out how to best draft my claims, right? Do I have to can I draft broad claims? Do I have to get narrow, right? How narrow do I have to get, right? Understanding that similar technology out there is great in understanding how do I draft the best claims moving forward, okay? We'll talk a little bit about later on about our prior art searches. One of our, our prior art searches are covered by our RLG guarantee, meaning if your search comes back not patentable for any reason, you would get a refund. You get your money back. We'll talk about that later. Okay, I want to talk about patent do's and don'ts. Okay, so we're at the point here where we found patentable subject matter in your software. Okay, or we've flushed out the novelty. We've done a search. We've identified the patentable subject matter. We think we can get meaningful claims from the prior art search report. Now we want to get into drafting. Okay, and we really want to be thinking about what are the do's and the don'ts. Okay. Point one, again, is identifying the novelty, right? Even though I harp on this, many times, excited inventors, excited chief technology officers, excited founders will talk about how, their system is going to change the world. It's going to revolutionize their industry, right? Without really talking about what's that single point of novelty that does that, okay? So identifying that novel aspect, that point of novelty, again, is the foundation for any patent, whether that's a software patent, that's a med device patent, that's the foundation. Okay. I want to talk second, and this is coming from having looked at hundreds of office actions, whether they come from they come from a different firm, they're sent to us to review. One of the biggest mistakes that I see when I look at this, and really when I'm looking at a 101 abstract rejection, is that the software doesn't clearly articulate what's happening, right? That the application doesn't clearly articulate how the software improves the functionality of your system or how a feature improves the functionality of your system. It may address that on a superficial level in the detailed description, but it's not clearly articulated in those claims, right? So articulating really how your software improves functionality and novelty is absolutely key, okay? The other thing I want to talk about is ensuring that you're identifying all the systems in your software component, all the components in your software system, right? Whether that's system, subsystems, components, neural networks, that is important for a number of reasons, right? And that's really going into drawing figures, right? And in the amount of drawing figures we emphasize, because it's going to help you not only in the instant application, but should you get an office action and we need to make amendments to the claims, we've got enough support in that original application to do that, right? Okay. Another don't, and something that I see far too much in software applications, is talking about generic functionality or automation. Okay, and I really talk about that as the last point in here in terms of aggregation and data compiling. Okay, remember, just simply automating a process that can be done by a human is not enough. You're going to get a 101 rejection. The examiner is going to say, yes, you've got software in here. The problem is all your software does is organize human activity. Okay, so automating something that can be done by humans by itself is just not enough. Okay, aggregating data or compiling data, okay, that is readily available, whether it's in the public, it's internal to your particular company, it generally is not enough, right? What does that mean? If I have a system that finds the best rates for hotel rooms or cars or Uber rides or watercraft rentals, okay, and I aggregate that data into one centralized database, again, that information can be found by looking at each individual website, right? And again, the danger you run into is that organizing human activity, that 101 abstract rejection. So really, if aggregation is one part of your system, it's important to note it's one part, but aggregation alone is going to run into 101 issues. Okay, same with compiling data, right? Too often I see applications where it can be in the medical industry, it can be in the construction industry, it can be in the retail home industry where data is compiled, whether it's for medical equipment, it's for houses in a city that are up for sale. Simply aggregating data that's known out there and compiling that data into one place is generally not enough. Okay, and that's going to lead you into a 101. Okay, so again, we want to be successful. We want to absolutely identify the novelty. We want to talk about the technical improvements our system's making. We want to ensure that we talk about how our system provides a technical functional improvements. Okay, and we want to ensure that all of our components, all of our features, all of our systems and subsystems are clearly identified, right? Because again, talking about the hardware that it's performed on is vital in a software application. Okay, I want to talk to you guys really quickly and kind of a handoff from the previous slide. What are the important parts of your application when we get there? The claim set. The claim set of your application is the most important part of any application. Okay, that's what the examiner is going to look at. That is going to be the focus if you have an infringement issue later on in federal court or at the patent trial and appeal board. The claims of your invention are really the heart of your invention, and that is where the majority of your time really needs to be spent. Okay, specification is very important as well, right? The more robust you can make your specification, the better your application is going to be for several reasons, right? First, it's going to define terms in your claim set that may not be clearly defined. It's going to talk about the how, right? How does what is the best mode for your software? It's going to talk about the enablement, right? Meaning, how do we enable a person of skill to build and perform your software? Okay, so the more robust your application is going to be is very critical. The second part, okay, is future prosecution. Okay, if you have a robust specification that's talking about all the components and it's very thorough, that's going to help you further on down the road should you run into an office action amendment or you're getting pushback on specific definitions or you have to define terms that may not necessarily be laid out clearly in your specification. So that robust specification, that robust detailed description is really going to help you should you have to make changes in the future. Okay, and again, our team will walk you through what we should be claiming in that specification, what kind of alternative embodiment should we put in there to help how best to explain how our software works to that examining attorney or that examining agent at the USPTO. And then lastly, I want to talk about drawings. Okay, drawings are vital, right, to your application, especially in the software setting. Okay, I emphasize that you should have at least 5 to 10 drawing figures. You need to have flow charts talking about the method of use for your software. You need to include systems architecture. You need to talk about the software components. You need to talk about how those components interact with one another. You need to be talking about if there's wireframes in there. Those are all going to aid the examiner in understanding how the software works, help identify the novelty of your software, but also aid in future prosecution, right? If you get a many times if you get a 101 abstract rejection and you can talk about the hardware, well, that right there will help the argument of overcoming that all your software is doing is merely an abstract recital of organizing human activity or another grounds under 101, right? I've included in here just some basic drawing figures in terms of networks, in terms of understanding system components, understanding systems, subsystems, functionality. Okay. I want to talk about filing techniques. All right, filing techniques is one of the most under talked about things with patent filings. Most people don't understand that there's really two ways to file a non-provisional patent application. You can file it the standard way, right? The standard way is, you include the spec claim, drawing money, filing documents such as your oath, if you're gonna sign a power of attorney, a micro entity if applicable. Okay. The USPTO advertises on their website that the pendency time, meaning, the time between filing an application and hearing a first action, right? First action being a notice of allowance or an office action rejection, is about 18.7 months. Okay. Again, software tends to be a little bit longer than that. That 18.7 months is really an average of all the art units at the USPTO. So please understand that software tends to be 24 to 29 months. Okay. One of the other things to keep in mind is the allowance rate for your standard filing is about 14% of applications are going to receive a notice of allowance on their first look. Okay. That is a low number, right? One of the things that we try and talk about with our clients is prioritized examination, right? What we call a track 1 prioritized examination request. And for software companies, this is something that you should absolutely be looking at. Okay, a prioritized examination request is simply a petition that you file with your application. Now remember, there's two times when you can file one. You can file one with your original application or with a RCE. Okay, a request for continued examination later on in prosecution. The advantage of the prioritized examination is that it really buys your way to the front of the line. Okay, what that means is instead of waiting 24 to 29 months, you're going to pay the USPTO based on your filing status anywhere from $1,000 to $4,000, and that's going to buy you to the front of the line. Okay, a lot of great advantages with track 1. Okay, 1, it guarantees final disposition in 12 months. That means you're going to hear back as well as be able to file a response within 12 months, right? So for most software companies, that is going to speed up prosecution by at least a year to a year and a half. Okay, the second thing that most people don't understand is the allowance rate for first action is 29% of applications that are filed through track 1 prioritized examination receive a notice of allowance in their first look. So you can see your chances of getting that notice of allowance are about double than filing the standard examination process. Okay. About 15 to 20,000 petitions for track one are granted every year, right? So, I emphasize that point simply because it's not a guarantee. If it's not, we can request refunds in like. But if you can take advantage of that for software companies, that will really speed up that examination process. Okay. Lastly, I kind of just put in here a basic diagram of track one versus standard, right? You can look with a normal application for software related technologies. It's about 2 years, right? So I say about 24 months. Sometimes it can go to 29. Track one, again, will be within 12. So if you could take advantage of that, I highly recommend doing it. Okay, I'm going to shift now from utility patents to design patents, right? Another way that the software companies don't really understand they can protect their technology is with a design patent application. You see this most commonly with graphical user interfaces, what we call GUIs. Okay, a design patent is a type of application that protects non-functional, ornamental aspects of your invention. Okay, so we're not talking about how the processor creates that output, how the machine works, what the functionality is. We're simply protecting the way something looks, right? So for design patents, right, graphical user interfaces meet the article of manufacture requirement by the USPTO if they're showed in the proper way. Okay, again, the same statutory requirements that it's new, it's novel, it's non-obvious apply. Okay, the USPTO allows for you to show a front view, a side view, a perspective view, environmental views. It will allow you to show multiple views of your graphical user interface if they're derived from the same screen. Okay. The advantage of designs is twofold. One, much faster examination process, 14 months examination process. If you file an expedited design, you're going to hear back in 2 to 4 months. A very, very quick process, and something that will definitely help protect some of those graphical user interfaces. Allowance rates. Allowance rates for design patents are 84%. Our firm is substantially higher than that with our designs. But again, the advantage is obviously much cheaper in cost, right? A design patent with our firm is about $28.50. We provide a money back guarantee if it doesn't receive a notice of allowance. When you take that $28.50 and you compare that to a utility application, that's going to be somewhere between 1/3 to 1/5 of the cost, right? So much cheaper, much faster, and a way to add another layer of protection to your software invention. Okay, on here I've included a couple of graphical user interfaces. If you have a Nest at home, you can see here's the graphical user interface for the Nest, and then 2 of these below here are going to be graphical user interfaces. Okay. Again, both of these derive from Apple. You can see that if you have an Apple iPhone, you can see that the home screen and the slide to unlock is protected with a design patent. Okay. Talk to you very briefly on copyrights. Copyrights is another form of protecting your intellectual property, right? A copyright is going to protect your code. Okay, so similar to a design, a copyright's protecting non-functional aspects. Okay, it's not going to protect the functionality. It's not going to protect, the how your system does it. It's simply protecting the ornamental aspects or the non-functional aspects of that source and object code. Okay, there are some advantages. Remember, a utility patent only lasts 20 years. A design patent lasts 15. The copyrights are going to last a lifetime of the author plus 50 years. Okay. The disadvantage of only having copyright protection is that if the code is rewritten, if it's changed, you can traverse that copyright protection, and it's not going to protect the functional aspects of your software. Okay. Last thing I want to talk about here before I open it up for questions: trademarks. Protecting your brand is key. Okay, protecting your brand is going to help you build brand identity. It's going to help distinguish you. If your software, your mobile app is on the Apple App Store or on different platforms, that is going to establish prima facie evidence that you're the brand owner. Okay, so trademarks are an invaluable part of your IP strategy. And really in software, you see it protecting a variety of things, whether it's the name of your business, it's the logo of your business, it's the name of a product, it's the name of a platform or feature. It can protect all of that. Now remember, trademarks can protect the name of the mark in what we call standard character mark, or it can protect a stylized mark, meaning, hey, it's got color, it's a logo, it's a stylized font. Okay, I included in here both some logo marks that you see like with Apple TV and Apple TV Plus on the right side. I also included some word marks where you see AirPods, AirPod Max, as well as Google, right? So these are generally used to protect both business names as well as products, okay? With that being said, I want to open up the floor to questions. We've got a few questions in here, and I'd like to start by answering the first ones out here. If you give me a second to read it, I will address them. Right. First question we have is, okay, what is considered public domain? Okay, that is a great question, right? What is considered public domain in terms of what, my software is released into the public domain. Okay, a lot of times clients, if they have a phantom version of the software, they're testing it within their own company, within their group, their friends and family, they're beta testing it to a limited group. That is not considered public disclosure. Okay, if you've disclosed it to customers, if it's out there in the public, right? If I can look it up, if I can buy that, or if I could, buy that subscription on a monthly basis or an annual basis, that is considered public disclosure. Okay, if you've got something in between, give us a call. Happy to go through and talk to you a little bit about it in the particular circumstances. Second question is, can somebody use an embodiment from my application and patent it? Well, the answer to that is no, they cannot. Right? Or no, they should not. Remember, an embodiment is just another way of showing your patent, okay, to the examiner for examination. Okay, with a utility patent, okay, if there's an alternative embodiment that's shown that functions the same way and somebody else is using it, that is arguably infringement. Right? Now, obviously, we have to look at how are they using it. What are the limitations of their system, right? What are the elements of their patent application or their issued patent? But arguably, no, they are not allowed to do that. Okay, let me go down to the next question. Okay, the next question, and I'm going to let Ken address this, as Ken is one of our attorneys here. The question, Ken, is if my software makes updates, right? I originally released it 18 months ago. I'm making updates. Does that qualify as new patentable subject matter, right? Now, as we know, most software companies are going to make anywhere from 50 to 100 updates in a year, right? Substantive improvements versus non-substantive improvements. I'd like to get your take on that, Ken.
Yeah, it's a good question because of the frequency with how often software is updated, right? There's a couple important distinctions I want to make, though. When we talk about software patentability, we're rarely talking about software as an entire operating system. If you think about how your phone operates or how your computer operates, we're rarely trying to capture the entire piece of software when it comes to patents. Ideally, we're going after specific novel, non-obvious features. So that way we're able to capture more infringers. It also increases our likelihood of patentability. So when you make updates along the way, those very plainly fall under the improvement category for patentability. patentable improvements to software for features are something that you should pursue. A question of how often you're pursuing those features as patentable subject matter is something we can talk about, right? Because we're probably not going to be filing patent applications for every patch you put out, right? That's rarely the case. But as long as we're meeting those features of novel and non-obvious, there's a very high likelihood you have patentable subject matter there.
Thanks, Ken. Appreciate it. Next question we got is what is the bright line test for determining organizing human activity under 35 USC 101? Okay, so let's take a step back on that, right? You file an application, okay, it goes to the examiner comes back and issues you an office action rejection, and they cite to 35 USC 101, meaning your software is too abstract to warrant patentability. All right, the examiner is going to cite in that reasoning, it's too abstract because that software simply organizes human activity. So what is enough to overcome human activity? Okay, because arguably the question is, hey, a lot of things and most things can be considered human activity. That's absolutely correct. What I would tell you is organizing, some of these tips, these do's and don'ts, we really talked about to address 101s, right? So organizing human activity, you're going to see when you're aggregating, right? Human activity, you're going to see in fintech when you're talking about hedging, or you're talking about risk mitigation, or you're talking about compiling data in a new way. Remember, that information is available out there. If you're automating it and just making it easier, you're going to run into a 101 rejection. Okay. If there's something you have a question about kind of outside of those examples, let me know. But again, kind of best practices, talk about what your software is doing, clearly identifying the functionality, talk about how it's improving the processor or a technical process, and avoid the standard traps of aggregation, data compiling, human methods, human activity. Okay. And if there's something I can answer for you, please give me a call. Question here is, am I correct in thinking that SaaS is a primary delivery vehicle and the underlying AI-based engine is a separate patentable requiring a separate application? Okay. I'm going to address this and then I'm going to turn it over to Ken for the next one. Okay. Again, software systems arguably can have one patentable thing or they can have multiple patentable things, right? Again, if you're, if your system is creating some sort of unique functionality, it's patentable. If the AI is the point of novelty for these systems, then the AI would be a separate patent. Okay. Now, let's talk a little bit about when you draft an application. The danger of drafting one application with arguably multiple patentable things, what we call multiple patentable subject matter in that application, is that the examiner can issue what we call a restriction requirement. What does that mean? It means the examiner is going to come back to you in their office action, and they're going to say to you, I've reviewed your application. There's multiple things in here that could be patentable. Okay. I have determined that claims 1 through X are directed towards a first invention. X through, X1 is a second application, and so on. Okay. So what that's saying is that, hey, there's multiple things in here that could be patentable. Okay. Now, what can you do at that point? Okay. There's a few things you can do at that point. The first one is that you elect, okay? So you're going to go back to the examiner and you're going to say, hey, examiner, the patentable subject matter in my application is directed towards claims 1 through 10, right? We'll call that species A or species 1. It's found in claims 1 through 10. I don't want to claim the stuff that's found in claims 10 through 20. So we're going to disclaim that. That will be removed, okay? The second option you have is filing a divisional patent application, which is Okay, I'm going to elect claims 1 through 10 are directed towards this invention, my SaaS product, and I want to preserve my AI-based platform or my neural network functionality, found in claims 10 through 20 in a divisional patent application. So they will allow you to file a separate divisional patent application, meaning you don't lose that, you don't disclaim that, that's now gone. You have an opportunity to file a second application through a divisional after you elect through that, what we call that restriction election. Okay. All right. Ken, next question for you, my friend.
Yeah, from the same user. Once registered, how much detail is publicly accessible from a patent application, and are underlying algorithms visible as well? There's quite a few things going on here in terms of requirements for how much you must disclose about your invention. But the short answer is we can't hide the novelty. We have to disclose the inventive concept, right? That may or may not include explicitly reciting elements of the algorithm, but generally when we're talking about patents, we're talking about structure and function of algorithms and not the code itself. Code is reserved for copyright, but the patent application and the detailed description in particular must meet what's called enablement. Enablement is the process of providing sufficient detail such that someone of ordinary skill in the art, that's a phrase out of the examination procedure, when they read your application, they need to be able to make and use your invention. That is a trade-off that you make with the USPTO when you file a patent application. If your patent issues, you have the right to exclude others from making and using and selling, but your published patent application also enables others to see how you did it. It's a give and a take with the USPTO. It's designed that way to encourage iterative improvements and designing around. So one part of your intellectual property strategy when it comes to patents also needs to be reading through what your competitors are doing and deciding how to design around that. And in some cases, patenting those technologies that you've designed around competitors for. And then just real quick on the last part of that question, I assume US patents do not work globally. How does one protect the invention internationally? That's correct. Patents are regional based on country. We handle both US-based filings and international filings. If you are going to be working in particular regions, we can file in specific countries. If you're looking for much more broad protection, there are international filings, such as something like a PCT or an EU application. That's going to depend heavily on where you intend to operate and sell your product. And we'd be happy to talk with you about that.
All right, thank you, Ken. I'm going to try and plow through some of these questions really quick. As I want to get as many questions answered as I can. Okay, question here about natural language processing, right? Question really is, can I protect natural language processing interfaces with a design patent? Okay, obviously natural language processing is been a hot topic when we talk about GPT-4 and that's supposed to come out later on in the year. We talk about GPT 3.5. Can a interface be protected? Yes, a NLP, natural language processing interface, can be protected with a design if it meets the statutory requirements. It's new, it's novel, it meets the article of manufacture requirement from the USPTO. So yes. Is there a specific theme or a specific look it has to have? No, again, we'll look at your particular interface and tell you what we think. We're going to do a search of that. Again, our designs include that money back guarantee. Should your design not receive a notice of allowance, you would get your money back. Okay. Next question would be, assuming a startup can successfully file a patent pending, how do you protect it against larger corporations, right? so great question, right? So we work with startups all the time, okay? And one of the questions and one of the fears that not just startups have, but any entity has is, well, say I get this protection, what's going to stop some big guy from coming in and squashing me because they can outspend me, right? Well, the answer is nothing, right? I hate to be the bearer of bad news, but again, if there's a larger company out there that's going to outspend you in legal fees, that's kind of a separate issue. If your patent incorporates the novel features and functionalities, and you've really got that in a patent, that's going to protect you, right? Now, whether or not it's a big company or not, whether or not they've got deeper pockets from you or not, having that solid patent is going to put you in a position to potentially license it to that larger corporation or sell it to that larger corporation. But there's no one type of protection that, hey, I can guarantee you that no larger corporation will ever try and challenge you. Unfortunately, there's just nothing out there. I will tell you, the chances that you're going to run into a litigation by some massively large company that is hell-bent on outspending you is less than 1%. Okay, so again, very great question, but the chances of that happening are not that high. Okay, let me see here. Are product design improvements and innovations patentable? Okay, is an innovation as a feature that has been improved from another company that takes several additional steps patentable subject matter? Absolutely. The question is absolutely. Again, that would kind of fall into that last point that we talked about as what are the technical improvements that you have made from that original system? How is that system deficient? What have you done to make it better, right? So is that patentable subject matter? It is. Again, we want to have a conversation with you. We'd want to really flesh out the novelty, the additional steps we've done, really talk about the technical improvement. And again, I look forward to speaking with you about that. Okay. Last question. And I'm gonna shoot this over to Ken. And I'm gonna try and wrap this up here as I know it's the weekend. Question is software that replicates a human labor function or task automation patentable?
Generally, the answer is going to be no when we talk about simple automation and organizing human activity, right? We've touched on that quite a few times already. That's not to say it's impossible to patent, right? Simply aggregate, I'm repeating Andy here, but simply aggregating data, something simple like that, taking what was previously done in an Excel spreadsheet and automating it may not be patentable. However, if the way that we're analyzing that data after we've gathered it, or we're storing it in a particularly efficient way, or now we're tagging and grouping it based on certain features that actually improve the performance of the processor doing the work, then we're much closer to patentable subject matter, I would say. Right.
Yeah, that's a great point. The answer, and again, not to sound like an attorney, is it depends, right? We really
it's always a case-by-case basis, right? Yeah.
So that is the last question we have. If I didn't answer your question or I missed it for whatever reason and you still have a question, please give me a call. Okay, my direct number is 954-332-6405. There's also the ability to book onto my calendar or book onto Ken's calendar. I really appreciate your time today in looking at what we've done, taking the time to watch our webinar. And I understand it's a Friday afternoon, it's Good Friday. So thank you everyone that joined. If there's something I can do to answer your question, I'm a phone call away. Okay, have a great weekend. Thank you again.